Hi students, good morning and welcome to the legal game presented by Unacademy. I'm Sarthak Sharma and yes, I'm meeting you after a lot of time. Almost after a week we are meeting again. I welcome to this you all to this wonderful platform because this platform makes your learning easy, effective, efficient and interesting. That's the reason that I always suggest you that it is going to be the best platform for your law entrance examinations preparation. Students, I have already taken two classes on this topic, the AILET 2021 questions discussion. Yes, All India Law Entrance Test is a very important entrance examinations, and yes, it is the most densely computed entrance examinations in the whole nation. मैंने इस सेशन पर ऑलरेडी दो क्लासेस ले ली हैं, but there were a lot of legal reasoning questions in this year's AILET. So only one or two classes were not enough to cover all the questions, and that's why I have come up with the third class of this session. Before proceeding, let me switch on the live chat. It will just take maximum 10 seconds. So I hope you will wait for that. All right, this live chat is on my screen now. Let's start. So All India Law Entrance Test, it is conducted every year by National Law University Delhi, NLU Delhi, for admission to its DLLB program. I hope you know this thing. And as I said, that AILET is the most densely computed entrance examination. More than 15,000 students appear for this examination for a mega sum of almost 75 to 80 seats. So, SIF for less than 100 seats, 15,000 students compete every year. And that's why it becomes the most densely computed entrance examination and the toughest entrance examination in the field of law, AILET. So, I hope you all are also targeting the All India Law Entrance Test. And mark my words, जो previous year papers होते हैं, the previous year papers are the Bible for you. They can be the game changer. Previous year papers can be the game changer for all of you. Yes, because these examination uh, tends to continue with the previous year patterns, and that's why I will suggest all of you that at least you should you should try these previous year papers. You should just इन सभी प्रीवियस ईयर पेपर्स को पिछले 4-5 साल के प्रीवियस ईयर पेपर्स को आपको घोल कर पी जाने हैं. These are going to be the biggest tonic, the biggest game changer in your preparation journey. Let's start with the class wherein I will discuss some more questions that were in this year's 2021 AILET examination. So students, let me give you a short intro of myself. I'm Sarthak Sharma. I'm a penultimate year law student at Faculty of Law, Jamia Millia Islamia. This institution had continuously been among the top 10 performers according to the NIRF ranking, specifically in the field of law. I have more than 2 years of teaching experience and I have mentored more than 10,000 students. I've always said this thing that for me each day count, and that's why instead of 2 years, I will rather say that I have more than 700 days of teaching experience, which is still counting. Today I'm going to add one more day to my experience, and yes, that makes me happy in the very first sense. And students, as I said that I have mentored, but my students have been of this view that sir, you have been less of a teacher and more of a companion in a preparation journey, and I admit with it. I admit मैं भी मानता हूँ that मैं अपने स्टूडेंट्स के लिए टीचर से ज़्यादा उनका कंपेनियन रहा हूँ उनकी प्रिपरेशन जर्नी में एंड with the mixed blend of their good luck and yes obviously their smart work and uh, my right mm, my right mentorship. A lot of my students have been rankers in the prestigious law entrance examinations of this nation like CLAT, SLAT, BLAT, JMILET, AILET, MHSET, CUCET, and a lot more. I hope you all are also going to add your name in this list. And yes, for that, I am with you. Moving forward, I'm on Telegram as well. You can join me on Telegram on that group. I share all the important stuff related to the classes and also the schedule of my classes every day. So if you want to join my Telegram group, I hope the screen is visible and the link is on your screen as well as in the description box. You just need to click the link and join the Telegram group. We will have interaction on that group. If you have any personal doubts, you can ask me directly in the Telegram group and I will definitely answer. Subscription, yes. Unacademy offers you a lot of unique features, but what is the doorway to subscribe to enroll for those features? The only way is to enroll to the wonderful courses of Unacademy, and for that you have to take subscription. The subscription can be for 1, 3, 6, 9, 12, 18 or 24 months, whichever is more feasible to you. मैं आपको suggest करूंगा कि at least 12 months से ज़्यादा subscription ही लीजिए. Right now there is a hefty discount. दिवाली भी आने वाला है, so दिवाली sale is going on 67%, 63%, 54% means there is a lot of discount. And in addition to these regular discounts, you can have an additional 10% discount by using the code SRT10. SRT is the short form of my name, SRT10. My name is Sarthak Sharma. And yes, SRT also stands for Sachin Ramesh Tendulkar. 10 was the jersey number of Sachin Tendulkar. So अगर सचिन तेंदुलकर की तरह अपनी फील्ड में एक्सेल करना है, then this platform is going to be a booster for you. There is no cost EMI as well for those students who do not want to pay in a lump sum. Students, you can have a look over the unique features of an academy. I said this thing that U in an academy stands for uniqueness. So these are the unique features. You can just have a look over them. And these six are some among a lot more unique features. बहुत सारे unique features हैं, उनमें से ये six भी हैं. So let's have a look over them. My favorite feature is the live quiz feature for the students. Now, what is this live quiz feature? So in this feature, the students can not only join a quiz, they can host their own quiz as well. वो सिर्फ क्विज को ज्वाइन ही नहीं कर सकते, वो होस्ट भी कर सकते हैं. Now what does this mean? Means this particular feature is itself evident of the fact that an academy believes in this thing that no one knows everything but everyone knows something. कोई भी सब कुछ नहीं जानता है, हर कोई कुछ ना कुछ तो जरूर जानता है. And that's why in this live quiz feature, the students can host their quiz. हो सकता है means like when I was in school, मेरा एक favorite subject था that was English and Geography. So उसमें मुझे इतना मजा आता था उसको पढ़ने में. यस, मुझको इतना मजा आता था कि कुछ ऐसी रिसर्च कर लेता था मैं टॉपिक्स जो शायद टीचर्स को भी ना पता हो. Obviously, so if you are interested, if something is some of the topics in your law entrance examinations fascinates you, जो आपके favorite हैं, then definitely you might be having some greater knowledge than others in that particular topic. And yes, you can help your fellow mates to gain that knowledge as well by hosting a quiz. सबका साथ सबका विकास अन अकेडमी पे ऑब्वियसली हो रहा है. So do use this feature, students. I hope you all are appearing for the ULAT, an Academy Law Aptitude Test. It's a 60-minute, 60 questions, 60 marks test that is conducted every Saturday at 11 a.m. And there's weekly T20 test as well, just on the theme of World T20. We hope India brings the trophy home, but you should also bring your trophy home. And what is your trophy? Your trophy is AIR1, All India Rank 1, nothing else. If you want this trophy, then you have to work hard. And not only hard, smart work. And what is smart work? Students कहते हैं सर आप बहुत smart work करते हैं. Smart work है क्या? So smart work is just hard work channelized in the right direction. जब तक आपका hard work right direction में channelize नहीं होगा, वो smart work नहीं बन सकता है. Okay, I have taken some strategy sessions. Do watch them. You will definitely have a clarity of thought that how to achieve this All India Rank 1. On Monday, there would be English, Tuesdays Quant, Wednesdays Logical, Thursday Legal, and Friday CE and GK. It is open for everyone. So students, even if you are not a paid user, you can appear for this 20 minutes quick revision test. Just have a look over the special class features. The Academy application is a better platform, much better platform when we compare it to YouTube, and that's why you can attend the special classes. These are free classes on Academy. You do not need to pay for it. These are free classes. Just download the Unacademy application. My profile link is also in the description box. Click on my profile link. I've taken a lot of special classes. You may attend them. Let's start with the class. Okay, in the first part of AILET previous year means 2021. Previous year का मतलब जो recent paper है. This year's paper, All India Law Entrance Test 2021. I have discussed already I've discussed 20 questions. In the first part, 10 question. Okay, and in the second part also 10 questions. It is the third part, so already we have discussed 20 questions. A total of 35 questions were asked in AILET this year from legal aptitude. Good morning, Vansh. I'm absolutely fine. I hope you are also fine. Yes, मैं बिल्कुल सही हूँ. I hope you are also good. डेंगू एंड कोरोना की बहुत अच्छी साझेदारी, बहुत अच्छी पार्टनरशिप चल रही है इस वक्त. So be safe, be secure, and enjoy your festivals. Let's start with the class now. The question is on your screen. You may have it. You may have a look over it. Just read it, and then I will show you the options. I hope all India Law Entrance Test 2021 के लिए कुछ the students who are repeaters. Yes, they are not droppers. I will not say that they are droppers because they are not stoppers. And if if you are a dropper but not a stopper, then absolutely you are going to be the next stopper. So All India Law Entrance Test 2021 previous year questions discussion. We have already discussed 20 questions in part 1 and 2. And it's part 3. It's the part 3 in which I'm going to discuss 10 more questions. टोटल ऑल इंडिया लॉ एंट्रेंस टेस्ट में 150 क्वेश्चंस आए थे जिसमें से 35 क्वेश्चंस 35 questions, even more than 35 questions. I think the exact number was 36 or 37, but 35 questions were there from legal aptitude. Some additional questions from legal GK as well. Let's discuss. First of all, you should read the principle. मैं आपको पहले ही बता चुका हूँ कि इन क्वेश्चंस को किस तरह सॉल्व करना है. Find out the correct answer, not the right answer. A right statement may be independent as well, but a correct answer is always the conclusion of the application of principle to the given facts. जब आप facts के ऊपर principle apply करेंगे तो जो conclusion आएगा वो correct answer होगा. Right statement is just something true. Like option में अगर लिखा है that the earth is round or 70% of the part of the earth is by water, it is true, but it is not correct because principle apply नहीं हो रहा है. Apply the principle over the facts and reach to the conclusion. Principle is related to nuisance, which may be a tort as well as a crime. Let's jump to the facts. Done? I hope you are done with the question. Let's move to the options and choose the correct answer. See, these questions either ask you to decide और एडवाइस. आपको इन दोनों में से ही कुछ एक करना होता है क्योंकि एग्जामिनेशंस आप लॉ करने के बाद क्या बनेंगे मींस यू कैन बी एनीथिंग. यू कैन बी एन आईएएस ऑफिसर, आईपीएस ऑफिसर, बट द मोस्ट ट्रेडिशनल ऑप्शंस आर ईदर जज और एडवोकेट. जज का काम होता है डिसाइड करना, एडवोकेट का काम होता है एडवाइस करना. So obviously these law entrance examinations tends to test that whether you are compatible enough to be a judge, means you have a good decision making power or not, or you are compatible enough to be a lawyer. A lawyer advises his client, a judge decides upon a case. तो आपको इन दो में से एक काम करना है, कोई तीसरा काम नहीं करना. In the principal fact questions, in the legal aptitude or legal reasoning questions, these examinations just test कि आपके अंदर लॉयर बनने की क्षमता या जज बनने की क्षमता मींस कैपेबिलिटी है या नहीं, whether you are capable enough to be a good judge or a good lawyer or not. And that's why these questions either ask you to decide like a judge or advise like a lawyer and advocate. I hope the principle and the facts is clear. Principle is the law for you. Now you have the law, you have the law, and you have the facts of the case. Okay, you have the law and you have the facts of the case. Now students, you are a judge and आपको अब decide करना है. Take the decision because your decision is going to be the right answer. Like in a regular court, in a normal court, The judge knows the law because he had studied law for the past 5 years and then वो एग्जामिनेशन को क्रैक करके जज बने. बट राइट नाउ यू हैव नॉट स्टडीड द लॉ, दैट्स व्हाई आपको लॉ दिया गया है एंड आपके लिए वही लॉ है. द लॉ, द प्रिंसिपल में भी हाइपोथेटिकल एज वेल, रिमेंबर. हो सकता है प्रिंसिपल में लिखा हो दैट मर्डर इज नॉट अ क्राइम, इट्स अ मॉरल एक्ट. आपको अपने फैक्ट्स के लिए वही मानना है दैट मर्डर इज नॉट अ क्राइम, इट्स अ मॉरल एक्ट. ऑब्वियसली इट्स नॉट reality that it is not, but for you the principle is the only law. For a judge, the actual law is the law. The law of this land, the law of the nation are laws for a judge because he knows the law. Try to answer. Okay, Mr. and Mrs. XYZ will be unsuccessful or will be successful. सबसे पहले आपको यही डिसाइड करना है. If they will be successful, then unsuccessful वालों को eliminate कर दीजिए. I have taught you the elimination strategy. There are two ways to answer a question. जब हमें आंसर नहीं पता होता तब either a smart guess or a wild guess. वाइल्ड गैस करते रहेंगे तो अगर आपने वाइल्ड गैस किए देन ऑब्वियसली नेगेटिव में स्कोर जाएगा. ऑलराइट, वाइल्ड गैस इज नॉट एडवाइजेबल. वाइल्ड गैस मींस आउट ऑफ द फोर ऑप्शंस यू डू नॉट नो एनीथिंग और आप कहीं भी तुक्का मार देते हैं. नहीं, इतना, बिकॉज द प्रोबेबिलिटी ऑफ गेटिंग करेक्ट इज just 1/4 and the probability of getting incorrect is 3/4. Out of 4 there are 3 chances that you will be wrong. Out of 4 there is just 1 chance that you will be correct. But a smart guess means you can eliminate options. केबीसी में 50-50 की एक लाइफलाइन हुआ करती थी. इफ यू कैन एलिमिनेट वन और टू ऑप्शंस देन गो फॉर द गेस एज वेल, बिकॉज यहाँ पर आपकी प्रोबेबिलिटी करेक्ट होने की भी 1/2 है और इनकरेक्ट होने की भी 1/2 है. एंड फॉर अ करेक्ट आंसर यू विल हैव 4 times more score. 0.25 is the negative marking and plus 1 is the marks that is given to you for every correct attempt. So I think if I would be the judge, facts मेरे सामने और law भी मेरे सामने, the law is saying that nuisance shall be defined as use of land in a manner that causes unreasonable interference with anyone's enjoyment of the land. अगर हम किसी की भी लैंड के एंजॉयमेंट में unreasonable interference करेंगे then it is nuisance. Simply, I have taught you nuisance as well. When I took the class on types of torts, I taught you nuisance, I taught you trespass, and I taught you the difference between nuisance and trespass as well. Nuisance is indirect interference, and trespass is just direct interference. When I enter someone property, I commit trespass. मैं किसी के घर में घुसा, मैंने trespass किया. बट अगर मैंने किसी के घर में, मैं खुद अपनी बॉडी लेके एंटर नहीं हुआ एंड आई एंटर्ड समवन हाउस विद इंटरफेरेंसेस, लाइक मैंने किसी के घर के बाहर बहुत लाउड म्यूजिक बजा दिया, इट इज न्यूसेंस. मैंने किसी के घर के बाहर स्मोक जलाया और वो स्मोक उनके घर में एंटर करा, इट इज न्यूसेंस. हियर आई एम एंटरिंग हिज लैंड इनडायरेक्टली बाय स्मोक, बाय साउंड, बाय स्मेल. मैंने गार्बेज फेंक दिया किसी के घर के बाहर, स्मेल जा रही है घर में के अंदर, ऑब्वियसली इट इज न्यूसेंस. So nuisance is unreasonable interference with another's enjoyment of their land, and the interference can be interference should always be indirect. Later on, it is written that it is no defense. जब हम किसी पे nuisance, जब भी हम किसी पे अटैक करते हैं, अटैक means attack may be in the court of law or naturally. जब हम किसी पे अटैक करते हैं तो वो इंसान खुद को बचाता है, he defends himself. Similarly, when we allege someone in a court of law that the person is committing a crime, then he takes defense to escape liability. So later the principle says that it is no defense to a claim of nuisance to say that plaintiff knew the interference that would be caused. मीन्स जब न्यूसेंस का केस हम किसी पर फाइल करेंगे तो वो ये डिफेंस नहीं ले सकता है कि प्लेंटिफ को नॉलेज थी कि इंटरफेरेंस हो रहा है. ऑल राइट, इट इज नॉट अ डिफेंस टू एस्केप द लाइबिलिटी फॉर न्यूसेंस. एंड हियर द फैक्ट्स आर सेइंग दैट द प्लेंटिफ हैड द नॉलेज, बट ये नॉलेज वाला डिफेंस नहीं ले सकता है डिफेंडेंट. And that's why the plaintiff would be successful. Because the plaintiff would be successful, so let's eliminate option A, which says that it would be unsuccessful. Let's eliminate option C as well. It is also saying unsuccessful. Now we have two correct answers, but we have to choose the most appropriate one. Appropriate one means there should be correct answer along with correct reason. Okay, there is a principle of natural justice which says reasoned decision. There are three principles of natural justice. पहला है ऑडी एटेम पार्टेम, which means hear both sides. Second is nemo judex ex causa sua, means a person should not be a judge in his own cause. And third one, a reasoned decision. डिसीजन ही नहीं देना एक जज को डिसीजन के साथ रीजन भी देना है, दैट व्हाट इज द रीजन बिहाइंड द डिसीजन. Okay, and that's why, due to this third principle of natural justice, you should give a reason as well for a decision. There are two correct answers, but you need to find the most appropriate one, and appropriate one means correct answer. There shall be a correct answer along with correct reason. सही जवाब और सही कारण दोनों होना जरूरी है. Let's see what option D is saying. Mr. X, Y, Z, Mr. and Mrs. X, Y, Z will be successful because they are old and have a right to live peacefully. Principle is nowhere saying that if someone is old, किसी की एज ज्यादा है तो उसको पीसफुली राइट है रहने का, एंड किसी की एज कम है, समवन हु इज यंगर, तो उनको नहीं है. इट इज समथिंग मॉरल, नॉट लीगल. हम मॉरल कह सकते हैं कि हमें बुजुर्ग लोगों को पीसफुली रहने का राइट देना चाहिए, बट इट इज नॉट लीगल. B would be the correct answer. Mr. and Mrs. XYZ will be successful because use of cricket ground is causing unreasonable interference with their enjoyment of their home. Obviously, it is. And further, the cricket club cannot claim that Mr. and Mrs. X brought trouble to their head. Because the principal is saying that even if the person has knowledge of the interference, then also it is no defense for the defendant. This thing. It is no defense to a claim of nuisance to say that the plaintiff knew of the interference that would be caused. Even if the plaintiff knew कि interference होगा, तो भी इस बात का डिफेंस डिफेंडेंट नहीं ले सकता है एस्केप करने के लिए लाइबिलिटी को. एंड दैट्स व्हाई द क्रिकेट क्लब वुड बी लायबल एंड मिस्टर एंड मिसेस XYZ आर एंटाइटल्ड फॉर डैमेजेस. डैमेजेस कंपेंसेशन को लॉ में डैमेजेस बोला जाता है. डैमेज इज लॉस एंड डैमेजेस इज कंपेंसेशन फॉर द लॉस. The second question is on a screen. Read the principle. Invasion is always direct. Obviously, who can be a trespasser? Any person who is not an invitee, who is not an invitee, or a lawful visitor is a trespasser. See, trespass is a crime as well as a tort. The only difference is that a tort of trespass can be unintentional as well. Torts में mens rea की जरूरत नहीं होती है. Torts unintentional भी हो सकते हैं. Means अगर मैं गलती से भी किसी के घर में एंटर कर जाता हूँ and I'm not an invitee or a lawful visitor, then I have committed tort of trespass. But in law of crimes, there shall be mens rea. There shall be a guilty mind. The principle is related to trespass. एंड ऑब्वियसली आपने बहुत सारे घरों के और प्रॉपर्टीज के बाहर एक बोर्ड देखा होगा, उस पर लिखा रहता है दैट ट्रेसपासर्स आर नॉट अलाउड. व्हाट आर ट्रेसपासर्स? एनी पर्सन हु पासेस ऑन टू समवंस प्रॉपर्टी, जो किसी की प्रॉपर्टी पर चला जाता है, हु पासेस टू समवंस प्रॉपर्टी, एंड दैट पर्सन इज नॉट एन इनवाइटी. इनवाइटी मतलब मैंने उसको इनवाइट किया है अपनी प्रॉपर्टी पे. लॉफुल विजिटर मींस द पर्सन is legally justified to enter my property. इनकम टैक्स ऑफिसर्स जब रेड मारने आते हैं, उनके पास सर्च वारंट होता है, then they are not invitees. मैं उनको इनवाइट नहीं करता हूँ, but they are lawful visitors. A police when comes up with a search warrant and searches someone's house, the police officer is a lawful visitor. But if I'm none of the two, I'm not an invitee, I'm not a lawful visitor, then I'm a trespasser. Simply. Okay, let's read the facts. एंड द प्रिंसिपल इज टेकन फ्रॉम सीआरपीसी. ये सीआरपीसी का बहुत फंडामेंटल प्रिंसिपल है जो पावर्स ऑफ पुलिस से रिलेटेड है. व्हाट इज द करेक्ट आंसर? क्या यहाँ पर ट्रेसपास हुआ है? हैज द पुलिस कमिटेड ट्रेसपास? फर्स्ट ऑफ ऑल यू शुड take the decision that whether they have committed or not. If they have committed, then choose the answers accordingly. If they have not, choose the answer accordingly. I think police has committed trespass because a queen is not a judicial officer. एक रानी judicial officer नहीं होती. According to the principle, police personnel may enter or search property only on express authorization. एक पुलिस ऑफिसर तभी किसी के घर में जाके एंटर करके सर्च कर सकता है जब उसके पास ऑथोराइजेशन है फ्रॉम अ जुडिशियल ऑफिसर, विच मीन्स अ जज, एंड दैट्स द पावर ऑफ अ जज. यस, आपने वारंट वर्ड बहुत सुना होगा मूवीज में. जब भी विलन को पुलिस अरेस्ट करने आती है तो विलन बोलता है अरेस्ट वारंट है क्या? वारंट है आपके पास? तो व्हाट इज दिस वारंट? व्हाट डज वारंट एक्चुअली मीन्स? वारंट इज एन इंग्लिश वर्ड. वारंट मीन्स ऑथोरिटी और ऑथोराइजेशन. वारंट मीन्स ऑथोराइजेशन के जब एक जुडिशियल ऑफिसर, एक जज, अब जज इज अ बिग ऑफिसर. जज तो खुद जाएगा नहीं अरेस्ट करने किसी इंसान को. व्हेन अ जज want someone to be produced before him, तो वो वारंट इशू करता है to the police, and he gives this power to the police, or he delegates the power to the police to arrest that person or to enter someone's property and make the searches. तो ये जो पावर है किसी के घर में भी एंटर करने की या किसी को भी पकड़ के जेल में लाने की, ये पुलिस के पास नहीं है, जज के पास है. जज वो पावर डेलीगेट करता है पुलिस को, एंड देन पुलिस डज द सेम. सो द वारंट इज ऑलवेज इशूड बाय अ जज, अ मैजिस्ट्रेट और अ जुडिशियल ऑफिसर टू अ पुलिस ऑफिसर. बिकॉज ऑब्वियसली एक जुडिशियल ऑफिसर जो कि ए ग्रेड गैजेटेड ए ऑफिसर है, वो खुद ग्राउंड लेवल पर किसी के घर जाकर उसको अरेस्ट नहीं करेगा. इफ यू वांट समवन टू बी अरेस्टेड तो वो अरेस्ट वारंट इशू करेगा, वो पेपर पे लिख के डेलीगेट करेगा ये पावर पुलिस ऑफिसर्स को, एंड द पुलिस विल गो. पुलिस वर्क्स ऑन द ग्राउंड लेवल ना. पुलिस हैज द फील्ड जॉब. जज डू नॉट हैज द फील्ड जॉब. जज हैज द जॉब ऑन हिज चेयर. उसको सिर्फ बैठना है और डिसीजन देने. उनके डिसीजंस को एग्जीक्यूट करना है पुलिस को. दैट्स हाउ द क्रिमिनल जस्टिस सिस्टम वर्क्स. So obviously the queen is not a judicial officer. Nowhere in the facts it is written that queen was a judge or a judicial officer. A queen may be a judicial officer or may not be. But according to the facts, it is clearly stated that she was a queen. Nowhere it is written that she was a judicial officer. And that's why what should be the answer? Miss A will be successful. Miss A will be successful in filing the case of invasion of property, that is trespass. And here unsuccessful वाले options को मैं eliminate कर रहा हूँ. It is written unsuccessful. Let's eliminate. We have two correct answers. Let's find out the correct reason. Option A is saying Miss A will be successful since the queen was planning on quelling dissent through legal means. Do you know what is it? It is just an argument इन फेवर ऑफ द क्लेम ऑफ मिस ए. मिस ए के क्लेम के फेवर में ये सिर्फ एक आर्गुमेंट है, और आर्गुमेंट कौन कर सकता है? मिस ए का एडवोकेट. बट यहां पर आपको डिसाइड करना है, यू आर नॉट अ लॉयर ऑफ मिस ए कि आप आर्ग्यू करेंगे. लेट्स एलिमिनेट दिस. करेक्ट आंसर बट रॉन्ग रीजन. Right reason is option number C. Miss A will be successful since the entry of the police officer constituted an invasion of personal property without authorization from a judicial officer. C is the correct answer. The correct answer and the correct reason. इन दोनों का कॉम्बिनेशन आपको मोस्ट अप्रोप्रिएट ऑप्शन तक लेकर जाएगा. क्वेश्चन नंबर 3. Okay, the question is from contract law. Doctrine of Privity. I hope you have studied about writing rem and writing personam. Let's read it. ओके, आई होप इट इज क्लियर टू यू नाउ। पी क्यू के साथ एक कॉन्ट्रैक्ट में एंटर करते हैं कि अगर 50 रुपीज से कम पे आप इस लैम्प को सेल करेंगे देन आप 5 रुपीज मुझे पे करेंगे। सिमिलर कॉन्ट्रैक्ट में क्यू आर के साथ एंटर करते हैं एंड आर ब्रीचेस द कंडीशंस बिकॉज आर 50 से कम प्राइस 40 में सेल कर देता है प्रोडक्ट को। एंड नाउ P seeks to claim compensation from R. Can P will P be successful according to the principle? क्या P सक्सेसफुल होगा? Obviously नहीं होगा because he is not party to the contract. So P will not be successful. Clearly, the right answer is A. P will not be successful since there is no privity of contract between P and R. Now, what is this privity of contract? Privity of contract means that only parties to a contract have rights and duties towards each other, and that is called right in personam. Tort law में right in rem होता है. In tort law, all the rights are right in rem. Like nuisance is a tort. आई हैव द राइट कि मेरी प्रॉपर्टी में कोई भी अनरीजनेबल इंटरफेरेंस ना करे। कोई भी मीन्स कोई भी, ही मे बी मिस्टर ए, मिस्टर बी, मिस्टर सी, मिस्टर डी और मिस्टर एक्स वाई जेड। सिंपली सो राइट इन रैम is a right which is available against the whole society or whole public. But what is right in personam? In contract law, in a contract we have right in personam. A right in personam means a right which is available only towards a particular individual, only towards the party to the contract. Okay, and only towards and against, a duty towards and against, a right against a particular individual. I hope it is clear that what is the right in personam. Like I enters into a contract of sale of my car for 12 lakh rupees to with Mr. A. It's just a illustration में example दे रहा हूँ कि मैं Mr. A के साथ एक contract में enter करता हूँ that I will sell my car to him for 12 lakh rupees. I have the right against Mr. A to take 12 lakh rupees and Mr. A has the right against me to take my car, to take the possession and ownership of my car. अब ये राइट मेरा मिस्टर ए के अलावा किसी थर्ड पर्सन के अगेंस्ट नहीं है। मैं वो 12 लाख रुपीस मिस्टर एक्स वाई जेड, मिस्टर वर्मा, मिस्टर शर्मा किसी से नहीं ले सकता। आई डू नॉट हैव दिस राइट। दिस राइट इज ओनली अगेंस्ट मिस्टर ए। मिस्टर ए के पास जो राइट है वो सिर्फ मेरे अगेंस्ट है, वो मुझसे कार ले सकता है। ही कैन नॉट टेक द डिलीवरी ऑफ कार फ्रॉम एनीवन। इट इज राइट इन पर्सनम। Only parties to the contract have rights and duties towards each other, very simply, according to the privity of contract. P and R are not party to a contract. P का contract Q के साथ है, Q का contract R के साथ है. So if Q breaches the contract, P can claim compensation, and if R breaches the contract, Q can claim compensation, but not P. P is not party to a contract with R. Q is a party of contract with R. So the right answer is option number A. P will not be successful. Okay, P will not be successful, and the right reason is there is no privity of contract between P and R. They are not party to a contract. Fourth question. Okay, it is also related to contract law. मुझे सबसे easy question लगा AILET 2021 का. Out of all the 150 questions, it was the easiest one. Components to contract is essential for an agreement to be considered a contract. I hope you know that if the parties to any of the party to the contract is not competent, then the contract is void. Let's read the facts. यहाँ पे आपकी लीगल रीजनिंग और थोड़ा सा प्रेजेंस ऑफ माइंड दोनों ही अप्लाई होता है। रिमेंबर स्टूडेंट्स, इफ यू हैव चूजन लॉ एज योर करियर, देन रीडिंग शुड बी योर फॉरमोस्ट रिक्वायरमेंट जो आप में होनी चाहिए। यू आर नॉट अ गुड रीडर, यू कैन नॉट बी अ गुड लीडर। आई होप यू आर डन विद द क्वेश्चन। डन? Okay, and let's see the options. But was K competent to contract? First of all, the answer is yes or no. See, I can answer it without any option, and I'm reading this question only for the second time. मतलब मैंने जब AILET 2021 का पेपर देखा था, at that time I read this question और मुझे पढ़ते ही बहुत easy लगा. The right answer is obviously that he is competent, and the right answer, that's why for question number 4 is B. He is competent to contract because he entered into the contract after completing 18 years of age. Let's read the principle. Competence to contract is essential for an agreement. And what is competence to contract? A person who is a major means 18 plus. A person of un, who is not of who is not of unsound mind means a person of sound mind. And a person who is not expressly barred by law. Who is not expressly barred by law from entering into a particular type of contract. एक इंसान जो 18 प्लस है मींस मेजर है, साउंड माइंड का है, अनसाउंड माइंड का नहीं है, एंड एक्सप्रेसली बार्ड बाय लॉ नहीं है, ही इज कॉम्पिटेंट टू कॉन्ट्रैक्ट. ओके, एक्सप्रेसली बार्ड बाय लॉ, इसको आपको समझना जरूरी है. लाइक विजय माल्या इज अ बैंकक्रप्ट, वो भाग गया, सो द कोर्ट्स हैव डिक्लेयर्ड हिम barred by law from entering into any type of contract related to loans. लोन के किसी भी कॉन्ट्रैक्ट में वो एंटर नहीं हो सकते. मींस जो लोग क्रेडिट कार्ड यूज करते हैं उन्होंने देखा होगा बहुत सारे लोगों का क्रेडिट कार्ड में जब वो पेमेंट नहीं करते हैं आफ्टर दे परचेज समवन ऑन समथिंग ऑन क्रेडिट एंड दे डू नॉट रिटर्न द मनी, उनका क्रेडिट स्कोर खराब हो जाता है. एंड क्रेडिट स्कोर खराब होने के बाद उनको लोन नहीं मिलता है बिकॉज दे आर एक्सप्रेसली बार्ड बाय लॉ नाउ. उनको लॉ ने ही बार कर दिया है फ्रॉम एंटरिंग इनटू दैट टाइप ऑफ कॉन्ट्रैक्ट. विजय माल्या, नीरव मोदी, अब ये लोग चाहकर भी इंडिया के किसी भी बैंक के साथ लोन कॉन्ट्रैक्ट में एंटर नहीं कर सकते हैं बिकॉज दे आर बार्ड बाय लॉ. बार्ड मीन्स प्रोहिबिटेड बाय लॉ. सो हियर जेड सॉट, मतलब जेड चाहता था खरीदना प्रॉपर्टी को जो कि के पास थी, वो एक माइनर था 2 days बिफोर के कंप्लीटेड 18 years. 18 years का वो होता उससे 2 दिन पहले जेड सिर्फ जेड वॉज जस्ट थिंकिंग इट, ही सॉट टू डू इट, बट आफ्टर 6 months ही डिड. सो आफ्टर 6 months, so obviously वो सिर्फ 2 दिन में 18 years का होने वाला था, तो आफ्टर 6 months he was a major, so the contract is valid and K was competent. When the contract was entered after 6 months, K was competent. Because सिर्फ सोचने से नहीं होता है. Z sought when K was a minor, but Z entered when K was a major. The fifth question. Acceptance must be communicated. Okay, this question is also related to Indian Contract Act. Communication of acceptance. I hope I've taught you this thing, not on the YouTube, but absolutely on the application. In a special class, I've taught this thing, that what is communication of acceptance and when this thing is necessary and when it is not. The only exception is general offers, जिसमें communication is not required. In all other offers, communication is required. Jay is alleging breach of contract. Is it a breach of contract? Acceptance must be communicated. Communicated means when the acceptance comes to the knowledge. Okay. And mere intention to accept without communication does not lead to a contract. Okay, सिर्फ intention ही काफी नहीं है. There shall be communication. Communication of acceptance का एक exception जरूर है, but that is general offers. General offers में communication is not required. And mere performance is enough. In general offers, communication of acceptance is not required. Communication is not required, and acceptance, mere performance according to the terms of the contract is enough. Mere performance amounts to acceptance. Now, what do you mean by this thing? But it is the facts are not of general offer. First of all, general offer with on offer which is made to the general public and not to a particular individual. Like किसी का बेटा खो गया और उसने न्यूज़पेपर में एडवर्टीजमेंट दिया that anyone who will find my son, I will reward him 50,000 rupees. It is a general offer because the offer is made to anyone. Anyone means any person from the society, not to a particular individual. So कोई भी इंडिविजुअल अगर उस अखबार के उस 50,000 के रिवॉर्ड को पढ़कर उसके बेटे को ढूंढ कर लाता है, then obviously the person would be entitled for the reward of 50,000 rupees, and उस इंसान को जिसने ऑफर दिया he had to pay because it's a general offer. He cannot claim this defense that the person did not communicated me the acceptance. Okay, because in general offers communication is not required, but in all other offers जब एक special offer होता है, special offer means made to a special person, communication of acceptance is also required. Acceptance करना तो जरूरी है, साथ साथ बताना भी जरूरी है कि हम accept कर रहे हैं. So according to the facts, J's allegation are wrong. There is no breach of contract because there was no acceptance, and that's why for question number 5 the right answer is D. J will be unsuccessful. हम सक्सेसफुल वाले दो ऑप्शंस को एलिमिनेट करेंगे. ऑप्शन ए इज सेइंग जे विल बी अनसक्सेसफुल बिकॉज इवन दो द कॉन्ट्रैक्ट वाज बाइंडिंग, टी फाउंड अ बायर हु ऑफर नो. No, the reason is wrong, answer is correct. Here J will be unsuccessful since T's acceptance had not been communicated. Obviously correct answer and correct reason. Let's move to the sixth question. Okay, mistake of fact. Mistake of fact renders the contract void. I've taught you this thing. Then I hope you are clear with the facts. If you are, then let's move to the options. Is it a mistake? Is it a matter of fact? एल के एजेंट ने उसको पहले ही बता दिया था, रीड दिस थिंग. ओके, व्हाट इज दिस? व्हाट इज द राइट आंसर फॉर क्वेश्चन नंबर 6? द क्वेश्चन इज जस्ट आस्किंग दैट इज द एग्रीमेंट void on due to mistake of fact or not. Okay, the facts and the principle is clear. Let's move to the options. There is no mistake of fact because mistake सबसे पहले आपको नाम से समझ में आ रहा है, mistake गलती होती है. Mistake is never malified. Alright, mistake is just गलती. गलती और गुनाह में जो फर्क है वही एक mistake और एक offense में होता है. Okay, so obviously it was not a mistake of fact because L had a prior knowledge of the accident, and that's why the correct answer for question number 6 is C. Since L was aware that the goods were lost, that's why it is not mistake of fact. Mistake of fact is a genuine mistake. It was not a genuine mistake. Means this contract would be voidable because here L had done fraud. Okay, but it is not mistake of fact. So no, since L was aware that the goods were lost is the correct answer and the correct reason. L had dishonest intentions. Obviously हमें fact से पता लग रहा है that he had dishonest intentions, but the most appropriate one is option C. Okay, let's move to the seventh question. when a defendant brings onto their land anything which is, I think this principle is of strict liability. तो स्टूडेंट्स आपको समझ में आ रहा है कि आप एग्जाम में किस तरह टाइम बचा सकते हैं. द प्रिंसिपल इज रिलेटेड टू स्ट्रिक्ट लाइबिलिटी एंड यू हैव आई हैव ऑलरेडी टॉट यू स्ट्रिक्ट लाइबिलिटी. तो अगर आप AILET 2021 के पेपर में अपीयर कर रहे होते देन डेफिनेटली आप लोगों का टाइम बचता, बिकॉज ये प्रिंसिपल आपको पढ़ने की जरूरत ही नहीं होती. विदाउट रीडिंग द प्रिंसिपल आपको पता है कि स्ट्रिक्ट लाइबिलिटी क्या होती है. बिकॉज इन एग्जामिनेशन व्हेन वी आर प्रैक्टिसिंग, व्हाट इज योर प्राइम टारगेट? टू एनहेंस नॉलेज. जब हम प्रैक्टिस कर रहे हैं, जब हम पढ़ रहे हैं, तो हमारा टारगेट है नॉलेज एनहेंस करना. बट व्हेन यू आर इन योर एग्जामिनेशन हॉल appearing for an entrance examination, what is your prime and the only target? Marks maximization. Without giving a second thought, without any out of doubt, आपका सिर्फ एक ही टारगेट होता है एग्जामिनेशन हॉल में, मार्क्स मैक्सिमाइज करना. इट कैन बी बाय हुक और बाय क्रूक. चीटिंग करके भी कर सकते हैं, ऑब्वियसली उसमें रिस्क है, सो नहीं करना. एंड मार्क्स मैक्सिमाइज इस तरह भी किया जा सकता है. If you already know the strict liability principle, then why you need to read it? Just don't read and go to the facts. And ये क्वेश्चन मैंने नहीं बनाए, AILET 2021 में है. स्टूडेंट सेट कि सर स्ट्रिक्ट लाइबिलिटी आपने इतने अच्छे से पढ़ा है, मैंने प्रिंसिपल पढ़ा ही नहीं, मैंने डायरेक्ट फैक्ट्स पढ़ा और राइट आंसर को चूज किया. एटलीस्ट यू विल सेव 1 or 2 minutes. यू हैव टू रेस विद टाइम ना. अगर इन्हीं 150 क्वेश्चंस को सॉल्व करने के लिए मैं आपको पूरा एक दिन दे दूं तो 150 आउट ऑफ 150 आ जाएंगे. बट आपको ये 150 क्वेश्चंस 90 मिनट्स में सॉल्व करने हैं. यू हैव टू रेस विद टाइम एज वेल, एंड दैट्स द बिगेस्ट फैक्टर. सो रीड द फैक्ट्स. I've taught you strict liability in detail. I told you that whenever a dangerous thing is brought to a land and if the things escape, okay, then the person would be liable for any loss even if he was not negligent. All the defenses in strict liability are there except the defense of inevitable accident. Tort law में जितने भी defenses हैं उनमें से inevitable accident नहीं होता है, बाकी सभी available हैं strict liability में. Let's read the facts. Okay, the tiger is obviously a dangerous thing. Okay. Is M liable? M के neighbor S ने cage open की. There is a dangerous thing. The dangerous thing escaped. Let's see whether all the ingredients are fulfilled or not. Later, the defendant can avoid liability if they can show that the situation that caused damage was a result of an unforeseeable act of a stranger which could not be controlled by the defendant. I taught you strict liability. सबसे पहले हम राइट ऑप्शन देखेंगे. सो द राइट ऑप्शन फॉर दिस क्वेश्चन फॉर क्वेश्चन नंबर 7 is undoubtedly option number C. M can escape liability because the escape was caused by the unforeseeable act of a stranger. That person, Mr. S, was a stranger to M, which could not have been controlled by M. Act of third party भी आप इसे कह सकते हैं. Third party means a stranger. If the escape is done by the act of third party, then the petitioner, then the plaintiff, sorry, the defendant, I'm saying, the defendant is not liable and the plaintiff cannot claim compensation. The right answer is C. M can escape liability. Strict liability बिल्कुल clear है आपको. Strict liability में I told you that there are total of 8 defenses in law of torts. Out of those 8, 7 defenses are available in strict liability. Only one defense is not available, and वो defense है inevitable accident. Apart from inevitable accident, all the other defenses are available in strict liability as well. The facts were of strict liability. There is a dangerous thing. A tiger is a dangerous thing. The dangerous thing escaped. Obviously, it escaped and did damage. एक dangerous thing है और वो escape करती है और किसी को damage होता है. So obviously, you will be strictly liable even if you are not negligent. But there are defenses to escape strict liability. There are 7 defenses. Out of those 7 defenses, act of third party is one of them. आउट ऑफ ऑल द जनरल डिफेंसेस इन टॉर्ट लॉ, इनएविटेबल एक्सीडेंट के अलावा बाकी सारे डिफेंसेस एप्लीकेबल हैं, एंड यस दिस डिफेंस कैन बी सक्सेसफुली क्लेम्ड एंड देयरफॉर एम कैन एस्केप लायबिलिटी। सी, एंड रिमेंबर अगर ये फैक्ट्स इस तरह होते कि एम मिस्टर मिस्टर एम के घर में एस एंटर कर जाता है एंड देन द टाइगर hurts him, then also Mr. M would not be liable, because यहाँ पर फिर escape नहीं होता। escape is compulsory। अगर मेरे घर में आग लगी हुई है और कोई मेरा नेबर मेरे घर में एंटर होता है और वो फिर उस आग में बर्न हो जाता है, इंजर हो जाता है, then he cannot claim compensation because there was a dangerous thing on my land but it didn't escaped। वहीं पर कुछ स्ट्रेंजर्स आते हैं, राइट्स हो रहे हैं, दंगे हो रहे हैं, और दंगों में जो लोग दंगा फैला रहे हैं उन्होंने मेरे घर में आग लगाई, एंड देन मेरे घर की आग उन्होंने मेरे पड़ोसी के घर में भी लगा दी। There is a dangerous thing, the dangerous thing escaped, but by the act of a third party, by the act of a stranger. So I would not be liable. The similar thing is there as well in the facts. Question number 8. Yes, this question also came in AILET 2021 examination. And students, this question is very important. Recently, इसमें judgment आया है. Mr. Harish Salve fought the case for Kulbhushan Jadhav. Okay, International Court of Justice by 15-1 majority found Pakistan to be in violation of obligations under which international law instrument? It was option number was the Vienna Convention on Consular Relations. Vienna Convention on Consular Relations. What are consular relations? Simply foreign relations. Foreign relations के ऊपर एक बहुत important convention है, and the International Court of Justice found Pakistan in violation of this convention. Question number 9. Who among the following was not a judge of the Supreme Court of India? Very important question. जस्टिस आर भानुमति ऑब्वियसली थी, ज्ञान सुधा मिश्रा भी थे, एंड रंजना प्रकाश देसाई हैड आल्सो बीन जज एट द सुप्रीम कोर्ट। राइट आंसर इज मंजुला चिल्लर, जो कर्नाटका हाई कोर्ट की पहली लेडी चीफ जस्टिस थी, एंड रिसेंटली वो रिटायर हुई हैं फ्रॉम द पोस्ट ऑफ चीफ जस्टिस ऑफ बॉम्बे हाई कोर्ट। शी हैड बीन चीफ जस्टिस ऑफ, आई थिंक शी हैव बीन जस्टिस ऑफ 2 or 3 high courts. Justice Manjula Chillar was the chief justice of Bombay High Court. Now she had retired, but she had never been on the Supreme Court. So Manjula Chilla is the correct answer. Option number C. It was an easy question. And the last question for today. Which of the following statements accurately captures India's position on torture? Is torture a crime in India? C. Harassment is a crime. Torture is not a crime. There is no particular legislation that criminalizes torture, neither it is in IPC. So obviously United Nations का एक convention था, that is United Nations Convention against torture. It has been signed by India but not ratified. What is the difference between signing and ratification? Signing means we are agreeing that we will obey this, but उसको obey करने के लिए अपने देश में कानून लाना जरूरी है. So they have signed, but the parliament has not brought any law to implement it till now. Parliament is soon going to bring it. I hope in the next session Parliament will obviously bring a bill, and वो bill pass होकर act बनेगा that will be against torture. So India has signed but not ratified. Okay, there are a lot of United Nations international instruments जिनको implement करने के लिए बहुत सारे laws इंडिया में इंडिया में legislate किए गए हैं by the parliament. So the B is the correct answer. Guys, with this I come to the end of this class. I hope you enjoyed the class. AILET 2021 के अगर इन questions का आप answer कर पाए हैं, then believe me, with each right answer you are going one step closer to National Law University Delhi, which is absolutely which is absolutely I think बेस्ट लॉ स्कूल इन इंडिया। मैं उसको एनएलएसआईयू बैंगलोर से भी ऊपर, इट्स माय पर्सनल ओपिनियन दैट इट इज बेटर देन एनएलएसआईयू बैंगलोर, अ perfect IIT for law. Yes, just like IITs are there in engineering, NLUs are there in law, but only the top NLUs. Students, there is a 1 year comprehensive batch for CLAT 2022. बहुत नजदीक धीरे धीरे CLAT 2022 आ रहा है. With each succeeding day, you are coming more closer to your destination, which may change your life. So 3rd of November is the date, means tomorrow. It's a bilingual course and it is for 1 year. You may enroll for it. You may enroll for Let's Crack Law 1.0 with 1.0, which is beginner's course for CLAT 2023, a 2 years program. It is also in English, which is in Hindi plus English, and the date is 5th of November. Aim high. Obviously, you should aim high. Yes, because the first step towards success is aiming. अगर आप aim नहीं कर सकते, अगर आपका vision उतना ऊपर नहीं है, तो आप उतनी height पर जा भी नहीं सकते. So aim high. It's a repeaters batch for CLAT 2022 for those students who are droppers but not stoppers. जो ड्रॉपर्स हैं लेकिन स्टॉपर्स नहीं है. एंड गाइस रिमेंबर, इफ यू आर अ ड्रॉपर बट नॉट अ स्टॉपर, यू आर गोइंग टू बी द नेक्स्ट टॉपर. और आपको टॉपर बनाने में हेल्प करने वाला है अनअकैडमी का एम हाई रिपीटर्स बैच कोर्स, विच had been launched yesterday only on 1st of November. There is no backlog of syllabus right now because अभी लॉन्च हुआ है. दिवाली के बाद हम अच्छे से पढ़ाना इसमें स्टार्ट करेंगे. It's also a bilingual course, a 1 year program which is a must for all the droppers who are not a stopper. You believe me, you are going to be the next topper. Guys, I hope you know about the bugs bounty. Yes, if you find any inappropriate content in the video, you can report it by using the link in the description. And with this, I'll end the class. Thank you. Please subscribe to this channel, hit the bell icon, like and share, and मेरे साथ मिलते रहिए, जुड़ते रहिए on YouTube as well as the application of Unacademy. Bye bye. Have a